Welcome back to our channel, and thank you for tuning in and thank you for supporting us. But if you're new to this channel and you haven't subscribed yet, please encourage us by doing so that we can bring you the latest news as they happen. And together we can support our leader, Mazi Nnamdi Kanu, IPOB, and Eastern Security Network to make our Biafran dream a reality and put the Fulani Janjaweed to shame. He say the Fulani Nigerian government has exhausted their wicked cards on Mazi Nnamdi Kanu's case, and now it is all over. And our leader, Mazi Nnamdi Kanu, will be coming out before his next court day. And victory shall be ours, because Biafra has finally come. And restoration is just around the corner. And nothing shall stop that to happen. No matter what the Fulani Nigerian government does, they cannot stop it. A motion filed by Mazi Nnamdi Kanu for the Fulani Terrorist Bandit Director General of Criminal Nigerian DSS to give oral evidence on his state of health has been rejected by the Fulani-controlled Federal High Court, Abuja. The Fulani Slave Justice Taiwo lied that fundamental rights cases are special case, which mode of commencement are affidavit evidence, just to cover up for the Fulani slave masters. But in the case of ﷺ, they never did that. They didn't say that it is fundamental right case. They exonerated him from all charges. No matter what the Fulani Nigerian government does, their game is over. And Mazi Nnamdi Kanu shall be released before his next court date, April 8th. And victory shall be ours, because Chukwu Okike Abiama has ordained that to be the position. Barrister ỌỌ̀_RJ, the special counsel to Mazi Nnamdi Kanu, has said there is a legal connection between the criminal Fulani police officer ﷺ and our leader Mazi Nnamdi Kanu. ﷺ, in an open letter to the criminal Fulani terrorist bandit Minister of Justice Abubakar Malami, said the update from Malami's office requesting further probe of some aspects of Abakari's investigation has created a new legal connection with Mazi Nnamdi Kanu. Barrister ỌỌ̀_RJ argued that if Malami could offer legal advice in contradiction or extradition process of Abakari, then Mazi Nnamdi Kanu is equally entitled to any legal advice that impacts his prosecution. On 13th March 2022, it was widely reported in the media that the Office of the Attorney General of the Federation issued a legal opinion / advice exonerating the Fulani criminal police officer DCP Abakari from the allegations of money laundering, which form the main basis upon which the United States of America is seeking Abakari's extradition to America. One of such publications in a well-respected national dailies was captioned, "Hush Puppy, New Legal Advice from AGF's Office Exonerates Abakari of Money Laundering Allegations." In as much as this legal advice does not sit well with certain segments of Nigerians and even the Americans that seek extradition of Abakari, it needs to be stated that the rendering of legal opinion or advice comports with the constitutional powers of the Attorney General of the Federation as preserved under the Constitution of the Federal Republic of Nigeria. Suffice it to say that this very legal advice exonerating ﷺ has created a new legal connection between ﷺ and Mazi Nnamdi Kanu. The connection lies simply in the fact if ﷺ is deemed entitled to such legal advice that will surely impact his extradition, Mazi Nnamdi Kanu is equally entitled to any legal advice that impacts his prosecution. In other words, the pertinent provision of the Nigerian Constitution and Nigeria's Extradition Act must be applied equally to all. Thus, Mazi Nnamdi Kanu is now entitled to the self-same legal advice, which must include the following. Under the universal doctrine of specialty, which pertains to extradition, an extradited fugitive, whether rendition or otherwise, is subject to prosecution only for those offenses for which he or she was surrendered, extradited, or renditioned. Nigeria recognizes this doctrine under Section 15 of Nigeria's Extradition Act, which provides that fugitive surrendered to Nigeria is not triable for any previous crime. To be sure, the foregoing provisions were, as regards Mazi Nnamdi Kanu, breached in all their material particulars. First, as of June 19, 2021, when Mazi Nnamdi Kanu was abducted in Kenya, he was facing 4-count charges, none of which included or bordered on terrorism. Today, the charges have been expanded to 15 counts that include and bordered on terrorism. Unarguably, this is a clear violation of the doctrine of specialty, especially in view of the proviso that a person falling within the section of Nigeria Extradition Act shall not be detained or tried for any new offense without the prior consent of the country surrendering him. In his case, Mazi Nnamdi Kanu's surrendering country is Kenya, and there is no evidence that Kenya's consent was obtained before these new 15-count charges were brought. Conversely, the same doctrine of specialty is also recognized in Kenya's Extradition Act. In view of the foregoing, it has become necessary for Abubakar Malami to revisit the matter of these new 15-count charges presently standing against Mazi Nnamdi Kanu with a view to urgently issuing a legal advice to the effect that all the new charges be withdrawn forthwith. Failure to do so will amount to a clear violation of the doctrine of specialty as enshrined in the Nigerian Extradition Act and equal protection of the law as preserved in the Nigerian Constitution. Thank you, my brothers and my sisters, for watching this video, and bye-bye for now.